Hello everyone. So today I will be doing a lesson again on the subject of legislative drafting and statutory interpretation. And today I will be focusing on the third lesson, that is drafting an act of parliament in Sri Lanka and in elsewhere. So my focus will be on the preparatory, the compositional and the scrutiny stages and the challenges that a legislative draftsman faces in these three stages while drafting an act of parliament in Sri Lanka and in elsewhere. So to give you a brief overview about what we are going to do, we are going to talk about the challenges in the preparatory stage, that is the careful study of the policy instructions, the design of a draft bill, the choosing of a good or a appropriate legislative precedent, then the constitutionality of the draft bill. Then we will move on to the compositional stage. In that we will talk about the use of plain language, then writing and composing the draft bill in such a way that it is logical. Then we will move on to the scrutiny stage, in which we will, the legislative drafter has to go through the various provisions of the draft bill one by one with reference to the policy instructions that have been given to him. So that is basically what we are going to talk about in this whole topic, under this whole topic. So it's not very difficult, it's easy to understand, and you will have to go through the note that have been provided for you. Other than that, it's not a very difficult topic to understand. So keeping that in mind, let's move on to the first topic, that is preparatory stage. So in the preparatory stage, the first challenge that the legislative draftsman faces is understanding policy instructions. Now, in Sri Lanka or in any other country, policy instructions that are given to the legislative draftsman is generally inadequate and is unclear. So therefore, it's very important for a legislative draftsman to understand what the government or what the relevant ministry expects from him. It's important for him to go to the relevant ministry and have some consultations as to whether what is truly required. So to do that, he has to consult the relevant ministry. So therefore, understanding the policy instructions, consultations with the relevant ministry is a must. Now, this is not a one-time thing. So legislative drafting takes a long time. So just going to the relevant ministry once will not do your job. So you have to have a good relationship with the relevant ministry so that you can visit the relevant ministry time to time to clear your problems or clear the challenges that you face along the way in understanding the policy instructions. Then, apart from consultation of the relevant ministry, it's also important to consult experts on that particular area. So, for example, if the draft legislation is on agricultural sector, then chances are that legislative drafter does not know about the relevant related legislation as well as the law related to the agricultural sector. So in such cases, if he were to gain some knowledge from experts in that certain area, the draft legislation would be of some quality. Therefore, to know about the practical problems arising out of such policy instructions as well as the law relating to the certain area, it's important that a legislative draftsman consult the experts in that area. So in understanding policy instructions, you have to consult the relevant ministry as well as you have to consult experts in that certain area, right? So keeping that in mind, now you consult the relevant ministry and you consult the experts in that area. Then the legislative draftsman has to ask the following questions. First, he has to ask whether such policy instructions require a piece of legislation, right? Then, if the policy instructions require a piece of legislation, he has to ask whether we can amend an already existing piece of legislation, or whether we have to draft a new piece of legislation. So, for example, if the policy instructions are very exhaustive and the draft amendment is also very exhaustive, it's prudent to draft a new piece of legislation, or to repeal and reenact a new piece of legislation, rather than amend an already existing legislation. So, for example, if a country wishes to move away from English statutes and write the statutes or draft the statutes in their vernacular languages, for example, in Sri Lanka, in Sinhala language, then it's more prudent to repeal and reenact the statutes in Sinhala language by repealing the English statutes, rather than amending the English statute. So, first the draftsman has to ask whether this policy instructions requires a new piece of legislation, and then whether it should be a amendment or whether it should be a wholly different piece of legislation, a new piece of legislation. Then thirdly, he has to ask whether these policy instructions can be given effect to by way of rules, regulations, bylaws or directives that are made under the Principal Act. Now, that is to say, for example, in Sri Lanka, the United Nations Act of Sri Lanka gives effect to Security Council resolutions of the UN by way of the before mentioned Principal Act. So, there is no different Security Council's Act in Sri Lanka. We give effect to the Security Council resolutions through regulations through the Principal Act, which is the United Nations Act of Sri Lanka. So, the legislative draftsman has to ask himself whether policy can be given effect to by way of bylaws, rules, regulations or directives, right? So, that is in terms of understanding policy instructions. Then we move on to the design of a draft bill. Now, when we design a draft bill, sometimes, most of the time, the legislative draftsman does not need to go through the painful process of designing a whole new draft bill, because he can choose a legislative president from either Sri Lanka or from any other state. That is to say, chances of such a legislation being done in another country or in Sri Lanka itself are very much there. So, if there is already a piece of legislation that addresses the same kind of issues, you can take that as a precedent to design your own legislation after. So, nowadays this is very easy because model bills are prepared by intergovernmental organizations, non-governmental organizations. So, legislative draftsman can follow this model bill. So, you can anyway choose any legislative president that is appropriate. Now, a good saying about this is that the use of legislative president is a very good technique because the wheel need not be reinvented. If the wheel has already been invented, then another country can use the design of the wheel for their own vehicles. Now, however, it's important that this legislative precedent that you have chosen has to be measured and dovetailed to suit your own legislative needs. That is to say, you cannot cut and paste the legislative precedent of another country. You have to measure and then you have to kind of dovetail it to suit your own needs. So the use of legislative precedent is called legislative transplant by Professor Helen Santaki. So it's a very appropriate term because basically you are transplanting something of another country, something of another organization to suit your own body, that is your own country. So don't forget the fact that you cannot cut and paste a legislation. You have to measure it, you have to cut it, and you have to dovetail it to suit your own legislative needs. That is design of a draft bill. Then when we talk about constitutionality of the draft bill, which comes under the preparatory stage, in Sri Lanka, before 1972 amendment to the constitution, the constitutionality of a draft bill was checked after the enactment of the draft bill. However, after 1972, the constitutionality of the draft bill is reviewed by the Supreme Court prior to the enactment of the draft bill. So today we check the constitutionality of a draft bill prior to the enactment of the legislation. Now, a very celebrated case is that we go through in every subject is Queen versus Lienage. In the case of Queen versus Lienage, what happened, I will just tell briefly because this will be talked about in every subject. So, in Queen versus Lienage, there was a military coup to overthrow the then president. So, now the military coup, however, was unsuccessful, and the people who planned this military coup was arrested, and then they were taken into courts. Now, during this time, when this case happened, we still had the chance to appeal to the Privy Council. So so what happened was, when these people, perpetrators of the military coup, were arrested, the government brought in a new piece of legislation known as the Criminal Law Special Provisions Act of 1962, which was enacted to enhance the penalty as well as to confiscate the property of these perpetrators. And what happened was, this case went on to the Privy Council, and in the Privy Council it was stated that this legislation, this new piece of legislation which was brought in wholly to punish these perpetrators, were ultra vires to the Constitution, as it was ad hoc, ad hominem, and ex post facto the Constitution, and therefore it contravenes the doctrine of separation of powers as enshrined in the Independence Constitution. So it was held that this legislation was ultra vires to the Constitution, and therefore it is not legal. Right? So you can see how the constitutionality of a draft bill could be challenged. So you have, as a legislative draftsman, you have to understand that your draft legislation has to be intra-vires to the constitution. Then we move on to the compositional stage. In the compositional stage, one of the most important challenges is the use of plain language. Legislation must be done in such a way that everyone can understand that piece of legislation. So, if the legislation is not comprehensible to the person who the legislation addresses to, then the legislation has no value at all. Therefore, it must be done in a very plain language that is understood by all, which is a very difficult task because generally legislation deals with very complex issues. Now, when we talk about the plain language in legislation, Professor K.W. Patchett has given a lot of points or principles to draft legislation in plain language. So I will just state few because it's not very difficult to understand. You can just read through it and understand what he says. So, for example, he says the legislation must be comprehensible by those to whom they are expressed. So, as I mentioned before, to whom the legislation is expressed must be able to understand the piece of legislation. It must be expressed in clear, concise, direct and authoritative statements. It should be certain and it should provide with precision for all foreseeable cases. That is very important because if the piece of legislation cannot address a situation that may arise in the future, then that piece of legislation does not hold any importance in that government or in that country. And so it has to be it has to address issues that may arise in the future. Then it should be expressed with simplicity and without ambiguity. It should be consistent with other rules. If that piece of draft legislation contradicts every other rule or every other legislation in that particular country, then that piece of legislation is not successful at all. So there are many principles that Professor K.W. Patchett has given, so you can go through them. It's not difficult to understand. It's just plain language plain language. So then we come to the second challenge in the compositional stage, that is the arrangement of an Act of Parliament. Now, an Act of Parliament must be arranged in such a way that it is easy to understand by statute users. Now, the provisions of an Act of Parliament can be divided into the preliminary provisions, the substantive provisions, the administrative provisions, and the miscellaneous or the final provisions. When we talk about the preliminary provisions, it includes the long title, the short title, the commencement clause, the interpretation section, purpose clause, etc. When we talk about the long title is a long label which describes the contents of the Act. However, it does not contain the purpose and the objects of the Act because it's just a label. Now, the long title can describe the Act as an amendment, consolidation, repeal or a replacement. The long title states what it is. Then the short title is a short label of an Act. It generally goes with the number and the date of commencement. Now, interpretation clause deals with the words of an Act and it's necessary to define some words as to the technical meaning that is attached to certain words. Now, the purpose clause, on the other hand, gives the object and purpose of the Act, which is different from the long title. Substantive provisions involves the establishment of a corporation, functions and powers of such an entity, composition of a directorate of a corporation, etc. Administrative provision deals with registration and licensing of an authority, withdrawals of benefits or incentives, etc. Final or miscellaneous provisions include offences and penalties, regulation making powers, savings and transitional provisions. Now, this final or miscellaneous provisions is very important because it gives teeth to punish those who contravenes the provisions. So it's not enough to just give the provisions. You have to have a mechanism to punish those who does not follow the certain provisions. That is done in final or miscellaneous provisions. Now we come to the third stage, which is the scrutiny stage. In the scrutiny stage must take a few days after the draft of after the legislation has been drafted. That is, you have to give a lapse of few days before you move on to the scrutiny stage. Now, scrutiny has to be done clause by clause by a third person or by a committee that is appointed for that purpose. So, scrutiny cannot be done by the legislative drafter himself because you have to have a fresh perspective as to whether the provisions are adequate enough. Now, a draft bill could be scrutinized by stakeholders. Those are people who are interested in that particular area. So, for example, again, if the legislation is on agricultural sector, then stakeholders would be experts on that area. Now, if you expose such draft bill for the scrutiny of stakeholders, we call it an exposure draft. So, for example, the Securities Exchange Bill of 2017 was subject to scrutiny by stakeholders. So, this is a very good method or very good technique because many deficiencies can be identified by those who are knowledgeable in that area. The legislative draftsman is knowledgeable in the area of drafting a legislation, and experts or stakeholders are knowledgeable in the subject matter of that legislation. So at the end product will be very rich and very practical legislation that is not merely merely a use of lot of technical words and gibberish, right? So in UK and in many Commonwealth countries, a cabinet subcommittee is appointed to go through a draft bill prior to the enactment of such draft bill. Now, legislative drafters, what they do is, now you give at the scrutiny stage, you give the certain draft bill to be scrutinized by a third person or a committee. If it's a committee, what happens is the legislative draftsman must go to these meetings that they which they scrutinize the legislation, and they have to make amendments on the recommendations made at such meetings by ministers and other technocrats. So after he makes these amendments, generally the draft legislation will be a much more useful and much more knowledgeable piece of legislation. So that is all for the topic drafting an Act of Parliament in Sri Lanka and elsewhere. So what you need to remember is that there are three stages: the preparatory stage, the compositional stage, and the scrutiny stage. And what you must remember that is, in all these three areas, there are certain challenges that a legislative draftsman has to go through. So to give you again an overview, in the preparatory stage, the understanding of policy instructions, design of a draft bill, use of good legislative precedent because the wheel need not be reinvented, then the constitutionality of a draft bill, because if it is ultra vires to the constitution, then the draft legislation is not going to be implemented in that country. And there the celebrated case of Queen versus Leon again. Then we talk about the compositional stage. In the compositional stage, we talk about how it's important to use plain language, because it's important for statute users to understand what is given in the statute. Then we talk about, in the compositional stage, how the contents of an act of parliament need to be given in a very logical manner. Under that, we talked about the long title, short title, etc. Then we come into the scrutiny stage. Scrutiny stage, we talk about how the legislation, the draft legislation, has to be scrutinized phrase by phrase by a third person or a committee. And we talked about how it's important to make it an exposure draft, that is to make it available to stakeholders to be scrutinized, and how it enhances the quality of the piece of legislation. So keeping that in mind, now you can understand that this is a very easy topic. So go through the note that have been provided to you, and I hope you understood what I explained. So have a good day, and have a good study hard in this time that have been given to you before the beginning of the law college.